Hello students. Today's topic, we are going to understand the word witnesses. Okay? Section 118 to 121 of the Indian Evidence Act 1872. Who is a witness? You know, judiciary is an important institution of the government. As you know, the famous French philosopher Montesquieu has given to the world the principles of separation of powers. There he has mentioned power should not be concentrated in one person, one organization, or in one department. Power corrupts, and more power corrupts the human being. So power should not be concentrated in one human being or in one department or in one organization. Power has to be divided. The governmental power has to be divided in a democracy. That's why it is called democracy. There has to be the legislative power, there has to be the executive power, and there has to be the judicial power. So, in India we have a parliament, that is the lawmaking authority, the legislative authority. We have the president and the governor, the executive authority. We have the Supreme Court and High Court, they are the judicial authorities. India is a democracy where we have this separation of power. Now coming to this court. Court is an institution established by the government for the benefit of the people, to solve the disputes of the people, to solve the crimes in the society. It's a very expensive establishment. The government appoints qualified persons as the judges of our court. The government appoints administrative staff, sincere, honest administrative staff to the court. Court is a public place where the parties will bring their disputes, will bring their crimes for solutions. Now, how the court functions? The court will be useful, will be functional only when it contains, when it will have the presence of both the parties to the case, both the witnesses, both the lawyers. When all these persons are present in the court, then the judiciary will be functional and it will be useful to the people. So in a court there is a judge, there are administrative staff, clerks, amina, there are two lawyers, plaintiff's lawyer, defendant's lawyer, prosecution, public prosecutor, and the defense advocate. And there has to be witnesses, both sides, witnesses, to favor their respective parties. Now the question, today's topic is, who can come to the court as witnesses? General knowledge. It's very general. Who can come to the court to give witnesses? Those persons who are of the age of majority, who are having sound mind, who can understand the questions and give the proper answers, the people having the knowledge of that particular case, they can come to the court of law without any fear, without any favor. They can come and present as witnesses. Now there is a question. Only the persons of majority are supposed to come and give the witness in the court? What about children? What about deaf and dumb persons? What about the junior judges? Can they come as witnesses? We will analyze one by one. Let us take the example of children. What is the child? A person below minority, boy or a girl below minority is called as a child or children. Can a minor, can a child come to the court of law to give evidences as a witness? There are number of cases on this topic decided by the Supreme Court. I'd like to give only one case. Okay? If you open up, so many cases are there. So only one case I would like to give. And this case is called Mohammed Sugal versus the King, 1945. I read again. Mohammed, not Muhammad. It is Mohammed Sugal versus King, 1945. Three sentences of fact. A 10-year-old girl, she is the only eyewitness to the killing of her father. There was a domestic servant. He has killed the father. He was holding the knife and coming out of that room. At that time, the daughter saw this. Later, the trial, police and the trial. In the trial, the 10-year-old girl presented herself as an eyewitness. She was asked questions by the public prosecutor and also by the defense advocate. She has completely understood the question and she has given correct answers for the questions. The question was asked sometimes even by the judge. But that girl, she has understood the questions completely without any hesitation. She started giving the answer. Perfect answers. As a result, there was a doubt about God, goddesses, oath. Okay? But she said, I am not sure about the presence of God or goddesses. I don't believe in this oath. I am not matured to understand the God and goddesses. But other things, she has complete knowledge. So here, the court said, in India, minors having the capacity to understand the happenings, the minors who can understand the questions and they can give proper answers, correct answers, then such evidence by the child shall be considered as a lawful witness. So in this case, Mohammed Sugal versus King, 1945, the court has given relevancy, importance to the witness of a child of 10 years of age. Okay, friends? Today, 2020, May 11th today, nowadays the children are so intelligent. Even 5-year-old, 6-year-old, 7-year-old children are very, very intelligent. They can give the answer. They can give the answer. Okay. Now one incident, okay, that's one case. I'd like to give one incident that took place in the city of Mysore city. In the city of Mysore. It's about a deputy superintendent of police. He, his wife, and some other members have visited a swimming pool in a 5-star hotel. There was a child. He was about 7 years of age. That's all. 7 years old boy. He was watching the killing of an innocent person by the police officer. Police officer has started giving blows to that innocent man and he was just pushed into the swimming pool, and the police officer prevented all other persons from saving that victim. This 7-year-old boy was watching completely, was watching the death of that victim in the swimming pool, where all the persons remain helpless. This case came up before the Sessions Judges Court of Mysore city, and that 7-year-old boy came forward to give the witness in the court. I even now remember that boy was very, very good in understanding the questions. The judge himself started asking questions to that boy, 7-year-old boy. And the judge was wonderstruck at the answers given by the boy. And finally, that officer was convicted by the sincere, honest, courageous judge. So, what I want to say is, children, whether they believe in God or not, whether they understand the religious book, sanctity of the religious book such as Bible, Quran, Guru Granth Sahib, Bhagavad Gita, Zandavesta, law is going to recognize the validity or importance of the child witness. Okay, that's enough. If they ask you a short note, this much is enough about the child witness. Now we will move ahead. In our country, there are special persons. By the unlucky persons, they may not be having the eyes, they may not having the capacity to speak, they cannot hear or listen. So, deaf, dumb, blind persons, can they come to the court of law? Can they become the witnesses? Yes, they have separate method of communication. They have separate method of communications. Questions can be asked to these three categories of people: deaf, dumb and blind people, and the answers can be secured by those methods only. And such answers can be translated to the language of the court. So, any deaf, dumb, blind people can also come to the court of law as a valid witness. We will proceed ahead. Can the judges, can the magistrate, can the munsif, if any crime, anything happens in their court premises, can they be called as witnesses? Judges of India have special protections, special immunities, special privileges. Judicial Protection Act provides the guard to all the judges of India. So, the junior judges may be called before the senior judges' courts, but the junior judges not to be called before the sub-junior judicial authorities or judges. Now let us take one small illustration. Consider a munsif court. A munsif court. Inside the court hall, suddenly one party gave a beating to the other party. It took place within few seconds. And the judge was in his place. He cannot get up and help. So, subsequently, the matter has gone to another court, criminal court. Now the question is, can this munsif be called as a witness to that criminal court? See here, that criminal law court where the matter is pending now, they will give a simple notice to the munsif with a direction please prepare a report and submit to us about the incident, that is the question before us. Then this Munsif, he need not go and present before the criminal law court. He can simply prepare what are the things that has happened. Okay? Prepare with the seal and signature and submit to the concerned court. So this is the protection available to all the judges of our country. Okay? So they must be protected. Their dignity must be protected. Their position must be protected. They should not be called as witnesses just like we call other non-judicial persons as witnesses. Okay, friends? Yes. That is about witnesses, section 118 to 121. We will go to the examination of witnesses. Very big topic. Section 135 to 166 of the Indian Evidence Act 1872. But for us, we will take only some 2-3 sections, that's all, not all the sections. Examination. How to conduct the examination of the witnesses in the civil court, in the civil case or in the criminal case. How to do this? And you know, here in a civil case means there is a separate law for that. All of you know there is a wonderful law called Civil Procedure Code. It is a religious book on civil matters. Orders, rule, sections, how to conduct the civil matters, civil disputes. So every civil court judge, civil advocates, they must have the knowledge of CPC. So all the civil litigation has to be conducted as per the CPC. And the other one, that is criminal cases, criminal matters. How to conduct the criminal matters or the criminal cases? There is another subject, wonderful subject, a very bulky subject. It is called Criminal Procedure Code 1973. All the criminal cases in India has to be conducted as per the procedure mentioned in the Criminal Procedure Code 1973. So, hope you know now. For civil cases, CPC. For criminal cases, CRPC. Indian Evidence Act says and explains about the examination of witnesses. The witnesses may belong to the plaintiff or the prosecution side, or the defendant or the defense side. Now, whoever may be the witness, they are the steps that has to be followed. Okay? So, we will understand the first one called as examination in chief. Let us consider a new case or a new criminal case is commencing. Okay? A new civil case or a new criminal case trial is going to take place. This is the first day of the trial of a civil case or a criminal case. First day. In a criminal case, the first day, both the parties, public prosecutor, prosecution witnesses, the accused and the defense witnesses, both the lawyers will be present in the court of law at the specified time. Later, the respectable, honorable judge enters the court hall. Immediately, all the people who are present in the court must stand up. Must stand up with silence. The judge will salute the court, and with dignity he occupies his seat. Only afterwards, all the people in the court hall silently, they have to take their respective places. Silently. On the first day, in a criminal case, the public prosecutor stands up. He will salute the judge and request him, "Your Honor, kindly permit me to open the case." And the judge will say, "Yes, Mr. Public Prosecutor, please commence the case." Then the public prosecutor will give a story about the case. He will explain the details of the party, how the crime has taken place, when it has taken place, at what time and at what place it has taken place. What are the reasons for the happening of the crime? What are the various evidences, oral evidences and documentary evidences? What are the chances of proof? He will say, sometimes he will say, "Yes, I have 100% proof, Your Honor. Allow me to speak." So in some cases it may take 10 minutes or 20 minutes or 30 minutes, the first day, the opening of the case. Then afterwards, the judge will say, "Okay, Mr. Public Prosecutor, have you completed?" Fine. Then the public prosecutor, saluting again to the judge, he will go and occupy his place. Then generally in the criminal cases, the judge will simply ask the defense advocate, "Yes, Mr. Defense Counsel, do you have anything to say?" And he will say, "Yes, Your Honor, my client is innocent. My client has not committed any crime at all. It's only an allegation. And I will disprove the allegation, Your Honor. I have sufficient proof, I have sufficient evidences. So we will proceed with the trial, Your Honor." Then in the criminal case, both the lawyers will be consulted by the magistrate or by the session judge, and both will be called. Okay, when both of you will be ready, we will commence the next stage, that is the stage of evidence, when we can start. Both the lawyers will have to give a date for the convenience, for the smooth proceedings. Both have to give a date. And the date will be notified to all, and the first day, the proceedings will come to an end and they will depart from the court. Right? Same thing happens even in civil case also. The first day of the case, trial, okay, opening of the case, who can open the civil case? The one who has filed the case, that is the plaintiff's advocate. Okay, he will open up the case. Right? Yes. So both procedure are same. Now let us come to the next stage. Okay, that is called the presentation of evidence by the public prosecutor. First by the public prosecutor, and afterwards the evidence by the defense advocate. Afterwards there will be arguments, stage of arguments, the artistic presentation of words, reasons, justifications. Arguments sometimes will be carried for 1 hour, 2 hours, 3 hours, sometimes even for few days. We have to remember the arguments of Ram Jethmalani ji, an eminent scholar, a wonderful advocate. Right. After the stage of argument, there will be the stage of giving the judgment. So judgment has to be given in the open court, in the presence of all the parties, including the accused, according to the circumstances. Right? Now we will analyze from the stage of presentation of evidence, either by the plaintiff's advocate or by the defense advocate or by the public prosecutor or by the defense advocate. Examination will contain these 3 methods or the steps, and these methods must be followed by all the people, by all the advocates. The first one is called examination in chief. Examination in chief. What is this? What is this? Let us consider a criminal case. Let us consider a criminal case. Public prosecutor has given the list of witnesses. The court has given him the permission to call upon those witnesses one by one. Consider the public prosecutor has called PW1, we will call, PW1 means prosecution witness number 1. When you come to the practice, you will know all these things. But now itself you try to gain few words. PW1. Prosecution witness number 1. Consider PW1 was called to the witness box. In every court there are two witness box, opposite directions. PW1 was called. In every court there are administrative staff. When the moment he was called, the witness will come, salute everyone, and he stand, and in some courts nowadays in India they have made a sitting arrangement. There is a chair for him to sit. When he comes to the witness box, the court officer will go to him with a book covered in a cloth, and that book may be Quran, Bhagavad Gita, Bible, or Zandavesta, or Guru Granth Sahib. And the court officer will make that person to touch the book, and the man has to say, has to repeat, I hereby make only the true statement and nothing else. If I make any false statement, I am liable for punishment. So this is the first method. Majority of Indians believe in the existence of God. Bhagwan par bharosa. They believe in the existence of God. Khuda hai, Bhagwan hai. हम झूठ नहीं बोलेंगे, हम सच, सिर्फ सच्चाई, हम सच ही बोलेंगे. So, first, the promise to tell the truth, it's called oath. Afterwards, the public prosecutor will rise from his seat and he will come and stand in front of the witness box. It is his own favorable witnesses favoring the party. So the public prosecutor will ask questions. In practical world, every lawyer, they have to call these witnesses to their office 2 days, 3 days, 4 days before the commencement of the trial. And every lawyer, for the success of his case, he will virtually tutor that witness. These are the questions I am going to ask, and you have to give these answers. This is the truth wherever you go in any part of India. This is the truth. So the lawyers, public prosecutor will come and he will stand and he will ask questions and the answers will be given. And there is a typist typist in the court, and the judge, he will dictate, and the typist will record. So all the statements made by the witness shall be recorded. Consider the public prosecutor has asked about 10 questions to the witness. He has answered. And afterwards, the public prosecutor will request the honorable court, honorable judge, "Sir, my examination is over, sir." Remember, this is called examination in chief. That means a lawyer conducting the examination of his own witnesses for the first time. I'm using the word. An advocate conducting the examination of his own witnesses for the first time is called examination in chief. After this, the public prosecutor has gone and took his seat. Then the defense advocate will rise, and the judicial officer calls him, "Mr. Defense Counsel, please commence your cross-examination." What is this cross-examination? There is a book called Art of Cross-Examination, a very small book, maybe about 100 pages, small book. Kindly read Art of Cross-Examination. Cross-examination is definitely an art, a talent of a lawyer. In the examination in chief, their own lawyers have strengthened the case by asking questions and securing the answers. Wonderfully, they have built the case. It is like a fort. It is like a strong, stony fort. Now, the cross-examination is an art to destroy that strong fort built by the first advocate. So for the purpose of cross-examination, the lawyers are classified into two kinds. One is called direct attacking lawyers, means those lawyers who are having a huge body, a tall body, a beautiful mustache, a hard face, a strong voice, when they go. Such lawyers will attack the opposite witness directly. They try to create fear in the mind of the opposite witness and to shatter their answers given in the examination in chief. Outstanding lawyers can do this, but they should have both the physical gift as well as the voice gift and the trickery. Right? Second kind of lawyers. Second kind of lawyers, they will approach the opposite witness in a very smooth manner, in a very friendly manner, in a smiling face. They want to enter into the heart of that opposite witness. They want to confuse the witnesses in such a manner that the opposite witness must feel, oh, this lawyer, I think he's also my own lawyer, because of his appearance, because of his smile, because of his smooth word, and if he loses his mind, the witness, then with this smile only, he will ask questions, and very smoothly he will ask questions, and that witness is going to give the desired answers by the opposite advocate, thinking that he is my own advocate. So those persons with a beautiful smile, a friendly face, a friendly appearance, a cool person can present the cross-examination. And in the cross-examination, the opposite advocate try his best to secure the answers favorable to himself and to destroy the answers and its validity given in the examination in chief. So, the opposite advocate will ask all the questions, and all the questions will be recorded by the court authorities, dictated by the judge. And finally, the opposite advocate says, Your Honor, I have completed my cross-examination. Then the judge will say, please, Mr. Defense Counsel, please take your seat. So there ends the examination in chief and cross-examination of one witness, PW1. Next comes re-examination. Generally, it may not happen. Generally, no. But sometimes, the advocate who has conducted the examination in chief, he might have forgotten to ask one or two questions in the examination in chief. He has forgotten to ask one or two questions. Then, after the completion of the cross-examination, he can request the judge, Your Honor, please permit me to re-examine my own witness. Please, Your Honor, I have failed to ask two questions. And the judge will say, I will give you the permission, provided you should not ask once again those questions which you have already asked. You should not ask. With this direction, the first advocate will be given an opportunity to cross-examine his own witnesses. Then that will be once again recorded by the court authority. And one of my students asked, what is this, sir? Only 3 kinds of examination. Is there any re-cross-examination? See that mind of you, the young India, how it works. I said, in our Indian Evidence Act, they have given only these 3 examinations. But now I can say, after your question, that why not? There has to be re-cross-examination, because after the re-examination of asking 1 or 2 new questions, definitely the opposite advocate has to be given an opportunity to conduct the re-cross examination, but it has not been explained and has not been mentioned in this Indian Evidence Act. Right, friends? Yes. All these stages, remember, it must be in an order. First is the examination in chief. This is the first level. And only afterwards, cross-examination. Only afterwards, re-examination. Only afterwards, re-cross-examination. This is an order. This order must be followed. Okay? That's good. So this is about examination. Now in the exam, they may ask you a short notes called leading questions. Leading questions. Section 141, 142, 143. You know, friends, let us analyze some of the simple questions which we ask in our life. All of you know how to ask simple questions. For example, they may ask you, what is your name? This is the simple question. And the opposite man will say, I am Kartar Singh from Ludhiana. I am Kartar Singh, or my name is Kartar Singh. One more question. What is your age? My age is 21 years. What are you? Answer. I am a student. Who is your father? My father is Javjit Singh. What is your profession? I am a farmer. Okay? So, there is a question, there is an answer. But see this leading questions. Leading questions, section 141. It says, combination of a question with the desired answer or the expected answer is called leading questions. Okay? Now let us combine some of the questions which we have asked so far. Are you Kartar Singh? Question is, are you Kartar Singh? What will be the answer? Oh yes, sir. Or yes or no. Yes sir, I am Kartar Singh, or no, I am not Kartar Singh. Okay? So the question contains the question and the answer. So, one more question. On the date of murder, were you not on the spot? Were you not on the spot? Answer: no, sir, I was not on the spot. So the advocate wanted to get the answer, I was not on the spot. So he has added that and asked the question. Right? Are you the son of Jagjit Singh? Answer: yes, sir, I am the son of Jagjit Singh. Are you a butler? Yes, sir, I am a butler. Are you the famous politician? Yes, sir, I am. So, some of the lawyers, they want to add the answers within the questions so that they can get the same answers from the opposite party. So such questions are called leading questions. Now the question is, who can ask this leading questions? Who can ask this leading questions? Leading questions should not be asked in the examination in chief, if objected by the opposite advocate. That means generally the lawyers should not ask leading questions to his own witnesses. Again, leading questions should not be asked in the re-examination. So who will conduct re-exam? The lawyers to their own favorable witnesses, to their own party witnesses, just like examination in chief. So here the law says, no, you the advocate, when you are conducting re-examination, you must not use the leading questions. Now you tell me, who can ask leading questions? Very easy. If you analyze these 3 points, you can easily say, who can ask the leading questions? Opposite advocate. Opposite advocate can ask leading questions, desirable answers, so that he can get the answers from confusing the opposite party's witness and secure the answer. Right? So leading questions can be asked in the cross-examination by the opposite advocate. Okay? So, leading questions. But leading questions can be asked by the advocates to his own witnesses when the own witnesses will become hostile witness under section 154. I'll let you know later. Now let me ask some of the, in this examination, See, there is a saying, what kind of questions can be asked by the advocates, both the advocates? What kind of questions can be asked by the advocates? See, there is a dignity in the court, and the dignity must be maintained, must be respected. Both the lawyers must maintain the dignity of the court. They can ask the questions to find out the veracity of the witness, to find out the trustworthiness of the witness, to find out the social status, the relationship of the witness with the party. Is he a real witness, or is he a bogus witness? So, questions can be asked only about these three things, these matters: unwanted, unrelated, dirty, inhuman, unethical questions should not be asked in the court. They should not use filthy language. Nowadays you can see in the social media using of filthy language. No. Dignified words must be used by both the advocates. Right? Yes. We will go to the next one, that is hostile witness. Short notes them ask you, section 154. You know, there are eyewitnesses. There are eyewitnesses. They will come to the court with a true intention to help the judiciary. They want to support the truth. They do not have any selfish interest. They do not have any motive of making profit. They are the true witnesses who will come to the court of law. Let us consider a plaintiff. He has given a list of 4 witnesses in a civil case. Consider a plaintiff has given a list of 4 witnesses. That is plaintiff's witness PW1, PW2, PW3, PW4. Plaintiff's witness are always favorable to the plaintiff. Whatever question they ask, they will give the answer favorable to the plaintiff and the plaintiff's advocate. Consider the plaintiff's advocate has called upon PW1. Plaintiff's advocate called upon PW1 in the witness box. And the court has given him the oath, administered the oath, PW1. He has taken the oath and promised to tell the truth. Immediately after the taking of oath, the plaintiff's advocate stood in front of the witness box and started asking questions to his own witness, PW1. Consider, the plaintiff's advocate asked one question, two question, third question onwards. The plaintiff advocate feel, no, his answer is dangerous to my side, is dangerous to my case, it is going to destroy my case, he wants to destroy my client. My own witness now has becoming my enemy. Then he can ask one or two more questions to confirm whether he is giving the opposite or contrary answers. Then, if the advocate is satisfied that he is contrary to my case, immediately he should show his request to the judge and tell him, Your Honor, here is PW1, our own witness, favorable to us, but please take down that he is no more our witness, he has turned hostile, he is against our own interest, his answers are hostile. Please declare him, Your Honor, that he is a hostile witness. This request by the advocate will be considered by the judge, and in the records he will say, PW1 is hostile. Then the advocate, plaintiff's advocate, is having the right to ask leading questions to his own witness to show him to the court how he became hostile. What was his earlier statement if he has already given some statement? And what was his statement now here standing in the witness box? If he has already given one written statement and that statement is different with this statement, and the advocate may tell the court, Your Honor, he is giving contrary and one of it is false statement, he deserves to be given the punishment. So, hostile witness. They are called the backstabbers. Sometimes they might have collided with the opposite parties. They might have taken the bribe or any profit from the opposite party, and they have conspired to give the contrary answer in the examination in chief, and such witnesses must be condemned by the law. And the plaintiff's advocate, he may stop him, he may be deleted from the list of witness, or he may request the Honorable Court to punish him for giving contrary statements. Okay, friends? So you may get a short notes for this word hostile witness. Remember, section 154 of the Indian Evidence Act 1872. So, dear friends, hereby I am concluding this topic. Thank you for your patience listening. God bless you.